Hello, my name is Bill Sessions. I'm Chief Judge of the U.S. District Court for the District of Vermont. I also am Chair of the United States Sentencing Commission. It's my real pleasure to speak with you today and to introduce the changes that we made to the guidelines system over this past year. Prior to the changes that we'll talk about today, the United States Sentencing Commission chose to travel the United States to listen. This was the 25th anniversary of the Sentencing Reform Act, which created the Sentencing Commission. And we chose to mark that anniversary by listening to judges, to defense lawyers, to prosecutors, to law enforcement personnel, to victims advocates, to advocacy groups. And we wanted to hear how the guidelines were doing across the country, and with the idea that we would accept those kinds of criticisms to try to implement changes. And as a result of the various hearings that we had, together with a survey that was conducted with all of the district and appellate court judges, we drafted and passed a number of very significant guideline amendments. And I'll talk to you just briefly about some of those highlights. The first is we changed the ways in which some of the offender characteristics are to be considered within the guideline structure. Generally speaking, after the Sentencing Reform Act, those offender characteristics were called not ordinarily relevant. Well, we changed that standard in regard to some of those characteristics to may be relevant, assuming that they are relevant in unusual circumstances to justify departures. More than that, in regard to specific offender characteristics, we also took on the task of educating judges and practitioners about how those particular factors may or may not be relevant in the future. We also expanded zones B and C of the guideline table for low-end offenders, giving judges greater discretion to provide alternatives to imprisonment if justice so requires. And as a part of that expansion of zones B and C, we also included a provision giving judges the power to use drug treatment or mental health treatment as an option as opposed to incarceration. We then reduced some penalties based upon criminal history scores of defendants in particular. We reduced the 2 points in the criminal history score that were generally implemented when a person committed the instant offense within 2 years of having been released from prison. What we found, frankly, is that those 2 points did little to improve our understanding of the risk of recidivism, and as a result, we reduced those penalties. Finally, after years of study and a number of reports from the Sentencing Commission to Congress, Congress passed the Fair Sentencing Act of 2010. And in that act, Congress reduced crack cocaine thresholds for mandatory minimum sentences and also passed a number of enhancements that were to be applied across the board to all drug trafficking offenses. We spent the last few months implementing that act. We passed guidelines which reduced the penalties for crack cocaine, and we also implemented the remainder of that act by incorporating various enhancements to all drug trafficking offenses which were mandated by Congress in that statute. Now, I invite you to listen as we go over all of the guideline amendments with you. It's been a very exciting year, and I appreciate very much the opportunity to speak with you today.
Hello, and welcome to our program. I'm Rachel Pierce, and I'm joined today by my colleague, Krista Rubin. In collaboration with the FJC, we are happy to be here to present Sentencing and Guidelines New Amendments for 2010. As the title indicates, today's broadcast focuses on the most recent amendments to the United States Sentencing Guidelines. And we have here our new Vermont Green Guidelines Manual, which will contain the majority of the new amendments that we will be focusing on today. The amendments that we will be discussing today went into effect on November 1st of 2010. Now, our goal today is to provide you with an overview of these new amendments and a greater understanding of the application of these new guideline changes. However, before we get started, we must briefly go over some housekeeping items as they relate to our program today. First housekeeping item, CLE credit. For those of you who are interested in obtaining CLE credit for this broadcast, please look to the FJC's DCN site for additional information, and you see that link to the website at the bottom of your screen now. Second housekeeping item, materials for today's broadcast. Also on the FJC's DCN site, you will find the materials that we will be using for today's broadcast. There are two documents that we have provided for you, and they are the reader-friendly version of the new amendments effective November 1st, 2010. Now, the reader-friendly version is a very useful version of the 2010 amendments. The reader-friendly version highlights the specific changes that have been made to the guidelines. Deleted language appears as struck through, and new language that was added appears as highlighted. A synopsis of each of the new amendments is also included. But for the official version of these amendments, however, please look to the new 2010 Guidelines Manual. The new manual can be accessed on the Commission's website at www.ussc.gov, and you see that at the bottom of your screen as well. The third housekeeping item, questions from our viewers. As detailed in the announcements for this program, we have been and are still accepting any questions that you may have about these 2010 amendments. One way you can get your questions to us during today's broadcast is to fax them directly into the studio to the number that you see on your screen now. We will be showing you that number periodically throughout this broadcast so that you can fax us your questions if you choose. In addition to faxing us your questions, you also have the ability to email questions directly to the FJTN studio, and you see the email address at the bottom of your screen there. So whether you're at your PC or you have your BlackBerry handy, you can just send us a quick email with the question that you have about these new amendments. We encourage you to send us your questions that you have regarding these new amendments, and we will do our best to answer them for you today. Final housekeeping item is today's agenda. We will begin our broadcast by discussing the Fair Sentencing Act of 2010 and the temporary emergency amendment to the guidelines promulgated by the Commission in response to the Act. This emergency amendment went into effect on November 1st of 2010, and then we will respond to questions that we have received regarding the Fair Sentencing Act. We'll then move on to discuss the regular permanent amendments to the guidelines promulgated by the Commission. These regular amendments also went into effect on November 1st, 2010. During our discussion of both the emergency amendment and the regular amendments, we will also address the Commission's amendment authority and the process by which the Commission promulgates these amendments to the federal sentencing guidelines. Finally, at the end of our broadcast, we'll try to save some time to answer some of the questions that we might have received from the viewers regarding these amendments.
Great. Well, we have a lot of material to share with you today, and so we're going to jump right into our discussion of the changes related to the Fair Sentencing Act of 2010. Now, this act, of course, was enacted on August 3rd of 2010. It is a piece of bipartisan legislation that is 2 decades in the making that addresses the disparities between the disparities in federal cocaine sentencing policy. Now, before I get into those changes, I want to show you our supplement that contains the emergency amendments in response to the Fair Sentencing Act. And I want to be clear about something. This supplement contains several guidelines: 2D 1.1, 2D 1.14, 2D 2.1, 2K 2.4, 3B 1.4, and 3C 1.1. I want to be clear that this supplement supersedes the guidelines that appeared in the manual that Rachel showed you all just a little while ago. Now, the legislation resulted in a number of statutory changes to the penalties for crack cocaine as well as other drugs too. Specifically, the legislation changed the amount of crack cocaine required to trigger the 5 and 10-year statutory mandatory minimum penalties for trafficking in that drug. This change in quantity reduced the penalty ratio between crack and powder cocaine from 100 to 1 to 18 to 1. And as shown on your screen, the statutory 5-year mandatory minimum penalty is now triggered by 28 grams of crack cocaine instead of 5 grams of crack as previously required. The 10-year statutory mandatory minimum penalty now requires 280 grams of crack cocaine instead of the 50 grams of crack as previously required. The second statutory change affecting crack cocaine defendants is the elimination of the 5-year statutory mandatory minimum penalty for simple possession of more than 5 grams of crack cocaine. And then finally, in addition, the legislation increased the statutory maximum fines available for drug trafficking offenses generally. Now, the Fair Sentencing Act also provided directives to the Commission regarding the implementation of this act. So as part of this legislation, which became law on August 3, 2010, the Commission was given emergency amendment authority to promulgate amendments to the guidelines within 90 days of the implementation of this act. These emergency amendments, therefore, took effect on November the 1st. So let's now begin discussing the emergency amendment to the guidelines promulgated by the Commission. So Rachel, why don't we just first take a look at how the emergency amendment addressed those statutory changes we just went through?
Sure, Krista, and I would just like to emphasize here that these first couple of changes that I will be addressing are only going to apply to offenses involving crack cocaine. As we continue our discussion, however, you will see that the other directives of this act contain other guideline amendments. Most of the emergency amendments apply to drug trafficking cases involving all types of drugs. So you'll see those distinctions as we go through our broadcast today. These two that I'm first discussing with you apply only to crack cocaine offenses. So the first change to the drug trafficking statute that Krista described is the change in the quantity of crack cocaine necessary to trigger a statutory mandatory minimum penalty. The first part of the emergency amendment conforms crack cocaine to the approach that's generally followed in the drug quantity table. And that is that base offense levels for crack cocaine are set so that the new statutory minimum penalties correspond to the offense levels of 26 and 32. As you can see from this slide, the changes to the drug quantity table for base offense levels we're showing you through 26 to 38 here. Again, the general approach followed at the drug quantity table at 2D 1.1 is to assign a base offense level of 26 to the quantity of drugs that triggers the 5-year statutory mandatory minimum. So as you can see here, at a level 26 for crack cocaine, you see the 28 grams that triggers that 5-year mandatory minimum penalty. Additionally, at the base offense level of 32, you see the quantity of crack cocaine, 280 grams, that triggers the 10-year mandatory minimum. Now, in order to get the other quantities for the base offense levels other than 26 and 32, the Commission extrapolated the quantities necessary to maintain the 18-to-1 ratio between crack and powder cocaine. Also, in Application Note 10D of 2D 1.1, there is new marijuana equivalency for crack cocaine. As of November 1st, 2010, 1 gram of crack is equivalent to 3,571 grams of marijuana. Now, the marijuana equivalency is used as a means for combining differing controlled substances. For example, if the offense involves both crack cocaine and heroin, you would use the marijuana equivalency for both of those drugs to determine the offense level. Commentary in the previous guideline manual about the method for combining crack cocaine and other drugs has been eliminated because now it's obsolete. The second statutory change addressed in this emergency amendment is the elimination of the 5-year statutory mandatory minimum penalty for unlawful or simple possession of crack cocaine. Now, to address this change in 21 Code Section 844, the Commission changed the guideline at 2D 2.1. The cross-reference at B1, which directed the court to apply 2D 1.1, which is the drug trafficking guideline, in a case in which the defendant unlawfully possessed more than 5 grams of crack cocaine, has been deleted from that guideline. But Krista, in addition to the statutory changes, there are also directives to the Commission as part of the Fair Sentencing Act that result in changes to the drug trafficking guidelines. So let's take some time now to talk about those.
Sure. Now, the legislation also directed the Commission to review and amend the guidelines to address certain aggravating and mitigating factors in drug trafficking cases to account for offender conduct. Now, please note that all amendments that we are about to discuss are applicable to all cases sentenced under the primary drug guideline 2D 1.1. These directives to the Commission are not limited only to defendants trafficking in crack cocaine. So whether the defendant is convicted of trafficking in heroin, in crack, or prescription drugs, these changes may be applicable. So let's first start with those changes for defendants sentenced under 2D 1.1 who also receive a minimal role adjustment, that is a 4-level decrease at the mitigating role guideline, which is 3B 1.2. These changes I'm about to go through are not available for defendants who receive either a 2 or 3-level reduction under the mitigating role guideline, only the 4-level reduction for minimal role. So first, there is a new maximum base offense level as determined by the drug quantity table for a defendant who receives a 4-level reduction for minimal role at 3B 1.2a. If the base offense level, as determined by the drug quantity table, is to be reduced pursuant to the mitigating role reduction at base offense level A5 under 2D 1.1, and the base offense level is greater than 32, the base offense level should be reduced to 32. Remember again, this reduction is only available to a defendant who receives a 4-level reduction under the mitigating role guideline at 3B 1.2 for their minimal role in the offense. Now, while we're discussing changes to defendants who are eligible for that 4-level decrease under mitigating role, we're going to jump ahead in the new drug guideline to talk about a new specific offense characteristic that the Commission added at subsection B15. This new mitigating factor permits a 2-level decrease if the defendant receives the 4-level reduction for minimal participant at 3B 1.2a and the offense involved 3 factors. The first of these 3 factors, found at B15a, requires that the defendant was motivated by an intimate or familial relationship or by threats or fear to commit the offense and was otherwise unlikely to commit such an offense. The second of the 3 factors, which is found at B15b, requires that the defendant receive no monetary compensation from the illegal purchase, sale, transport, or storage of controlled substances. And the final factor, the third factor out of the three factors, requires that the defendant had minimal knowledge of the scope and structure of the enterprise. So to recap, a defendant who receives a 4-level reduction at the mitigating role guideline at 3B1.2a, who also meets all three of the criteria listed in subsections A through C of specific offense characteristic B15, shall receive a 2-level decrease pursuant to this provision. And just to clarify, this 2-level reduction would be applied in addition to the mitigating role adjustment in the base offense level at 2D1.1A5, and in addition to the 4-level decrease at the mitigating role guideline. The application of these provisions is cumulative, as with all adjustments under the guidelines, unless the guideline specifies otherwise.
As we're starting to see, Krista, there's a lot of new information in these specific offense characteristics at 2D1.1. So now that we've talked about the mitigating factors, we're going to move on to focus on the aggravating factors that were added as a result of the directives to the Commission in the Fair Sentencing Act. The Commission was directed to make an additional 2-level increase for a defendant who, during the course of a drug offense, used violence, made a credible threat to use violence, or directed the use of violence. To respond to this directive, there is a new specific offense characteristic at 2D1.1b2, as you can see on your screen. This new specific offense characteristic provides an increase of 2 offense levels. Please also note that this specific offense characteristic is defendant specific. That is, this enhancement would not apply to a co-defendant who, as part of a jointly undertaken criminal activity, used violence or made a credible threat to do so. This enhancement only applies in the situation where the defendant himself or herself used violence as part of the relevant conduct of the drug offense. Now, consistent with our general application principles in 1B1.1, this new specific offense characteristic may be applied in addition to the specific offense characteristic at 2D1.1b1 for a dangerous weapon. However, take note, application note 3 at 2D1.1 is amended to state that mere possession of a dangerous weapon without the use, direction to use, or credible threat to use violence on the part of the defendant would not result in the application of this new violence-specific offense characteristic. Some of you may be asking, what about the relationship between the violence-specific offense characteristic and a conviction under 18 U.S.C. 924C for using a firearm during a drug trafficking offense? Well, the Commission has amended Application Note 4 at 2K2.4, the guideline addressing those convictions at 18 U.S.C. 924C. In a case in which the defendant is convicted of a drug trafficking offense and a violation of 18 U.S.C. 924C, the new violence enhancement at 2D1.1b2 shall not apply.
Now, the Fair Sentencing Act also directed the Commission to increase by 2 additional offense levels the penalties for a drug offense where a defendant bribed or attempted to bribe a federal, state, or local law enforcement official in connection with a drug trafficking offense. In response to this directive, the Commission promulgated a new specific offense characteristic at 2D1.1b11 that tracks the language of this directive. As you see, the new bribery enhancement is defendant-specific and provides a 2-level increase as directed by Congress. Application Note 27 was added to 2D1.1 to clarify that this specific offense characteristic does not apply if the purpose of the bribery was to obstruct or impede the investigation, prosecution, or sentencing of the defendant. Note 27 also states that conduct of that type is covered by Guideline 3C1.1 obstruction, or the Chapter 3 enhancement there, and perhaps the new super aggravating role-specific offense characteristic, which we will be explaining in just a few minutes. Next, the Fair Sentencing Act directed the Commission to provide a 2-level increase if the defendant maintained an establishment for the manufacture or distribution of a controlled substance as generally described in Title 21 of the United States Code, Section 856. In response to this directive, the Commission promulgated a new specific offense characteristic, B12, and a corresponding application note 28. As you can see from the slide, the new specific offense characteristic tracks the language of the directive. Application note 28 explains that this new specific offense characteristic applies to a defendant who knowingly maintains a premises for the purpose of manufacturing or distributing a controlled substance. The note also provides a definition of premises, meaning a building, room, or enclosure. Additionally, this new application note provides a list of factors for the court to consider in determining whether the defendant maintained the premises. These factors include whether the defendant held possessory interest in, that is, owned or rented, for example, the premises, and the extent to which the defendant controlled access to or activities at the premises. Application Note 28 goes on to state that the manufacture or distribution of the controlled substance need not be the sole purpose for maintaining the premises. The manufacture or distribution of the controlled substance must be one of the defendant's primary or principal uses for the premises, rather than an incidental or collateral use. The frequency of the use of the premises for lawful purposes and the frequency of the use of the premises for manufacturing or distributing a controlled substance is a factor that the court should consider in determining whether to apply this new specific offense characteristic. But there are other directives we have addressed as part of the response to the Fair Sentencing Act, so I'm going to turn it back over to you.
And now we're going to talk about the last of the new specific offense characteristics that was added in response to the Fair Sentencing Act of 2010. The Act directed the Commission to increase the offense level for defendants who are subject to an aggravating role enhancement under the guidelines for their role as an organizer, leader, manager, or supervisor of a drug activity, and the offense involved one or more super aggravating factors as outlined by the legislation. Now, as you can see from our next slide, the Commission promulgated a new specific offense characteristic at 2D 1.1 B14 to respond to this directive. A 2-level increase is provided for a defendant who receives an adjustment. Now, this is a 2 or a 3 or a 4-level adjustment at the aggravating role guideline at 3B 1.1, and whose offense involved one or more of the following 5 factors. And those 5 factors are listed in the guideline at subsections B14A through B14E. And we're going to take a look at each one of them individually. So the first aggravating factor at B14A has 3 components. As you can see, first, the defendant used fear, impulse, friendship, affection, or any combination thereof to involve another individual in drug activity. And drug activity includes the illegal purchase, sale, transport, or storage of the controlled substance. Second, the individual received little or no compensation from the drug activity. And third, the individual had minimal knowledge of the scope and structure of the enterprise. If the defendant is to receive an aggravating role and meets the 3 criteria that we have just reviewed, the defendant would receive a 2-level increase at this new specific offense characteristic, in addition to the role adjustment for aggravating role at 3B 1.1. The second aggravating factor, which is found at B14B, would apply in a case in which the defendant distributes drugs to certain individuals or involves these certain individuals in the offense. And the defendant must know that the individual was less than 18 years of age or 65 years of age or older, or pregnant, unusually vulnerable due to physical or mental condition, or otherwise particularly susceptible to the criminal conduct. Now, accompanying this factor is a new application note, 29A, which states that the individual that's described, this unusually vulnerable due to physical or mental condition, is not going to qualify as a vulnerable victim for the purposes of the vulnerable victim adjustment at 3A 1.1b. Also, if the defendant receives an enhancement under this subsection for involving an individual less than 18 years of age in the offense, the adjustment at 3B 1.4, which is using a minor to commit a crime, shall not apply. Krista, why don't you discuss the next couple of factors in this new specific offense characteristic?
Sure, and let me again remind you that the threshold, the first threshold for application of this new specific offense characteristic we're talking about is that the defendant receives an aggravating role adjustment at 3B 1.1. So they receive the aggravating role adjustment, and one or more of these factors that we're talking about would trigger application of this two-level adjustment. So let me move on to the next factor, which is found at B14C, and that factor addresses whether the defendant was directly involved in the importation of a controlled substance. Now, there already exists in Guideline 2D 1.1 two other specific offense characteristics that address importation. The first is found at subsection B3, and that provides an increase of 2 levels and an offense level of 26, where the defendant imported or exported drugs using an aircraft, submersible vessel, or acted as a pilot, captain, navigator, or something of that type. The second specific offense characteristic that already exists in the guideline to address importation conduct is found at subsection B5. And subsection B5 provides a 2-level increase if the offense involved the importation of methamphetamine or amphetamine. So as you can see from this next slide, if either of these two specific offense characteristics apply, that is B3 or B5, then the new increase at B14C would not apply to that particular defendant. Okay, on to the next factor, and this is the fourth of the 5 factors, and it's found at B14D. And this particular factor addresses whether the defendant engaged in witness intimidation, tampered with or destroyed evidence, or otherwise obstructed justice in connection with the investigation or prosecution of the offense. So if the aggravating role defendant receives an enhancement based upon this subsection, B14D, there's instruction that the enhancement for obstruction at Guideline 3C 1.1 shall not apply. Rachel, why don't you talk about the 5th and final factor that's listed at this new specific offense characteristic?
Sure, I mentioned there is a lot going on in this guideline. The 5th factor is at subsection B14E and is applicable to an aggravating role defendant who committed the offense as part of a pattern of criminal conduct engaged in as a livelihood. The terms pattern of criminal conduct and engaged in as a livelihood are defined in the same way that those terms are defined in the criminal history override, criminal livelihood, at 4B 1.3. So those of you who've been working with the guidelines for a while might be familiar with these definitions. And as you can see from our next slide, pattern of criminal conduct is defined as criminal acts occurring over a substantial period of time that may involve a single course of conduct or independent offenses. Engaged in as a livelihood involves a defendant who derived income from the pattern of conduct that exceeded 2,000 times the then existing hourly minimum wage under federal law in any 12-month period. Also, looking to the totality of the circumstances, showing that the criminal conduct was the defendant's primary occupation during that 12-month period. Okay, so the changes that Krista and I have discussed are those that the Commission has implemented under their emergency amendment authority in response to the Fair Sentencing Act of 2010. So to recap, we looked at the changes at the drug quantity table based on the statutory penalties for crack cocaine offenses. We also looked at aggravators and mitigators that present themselves in the form of specific offense characteristics at the new guideline at 2D1.1.
And don't forget, for the mitigating factors, the threshold determination is that the defendant receives a 4-level reduction for mitigating role at 3B1.2. So that's important to remember for those mitigating factors.
Absolutely. Now again, these changes went into effect on November 1st as a temporary emergency amendment. And as a temporary emergency amendment, the amendment is effective for only 1 year. As a result, the Commission plans to repromulgate this amendment as a regular permanent amendment during its regular amendment cycle, and we're going to talk a little bit more about that in just a few moments. Sometimes, in the case of an emergency amendment that is repromulgated as a permanent amendment, the permanent amendment may be a bit different from the emergency amendment that was implemented in response to the directive. The Commission is always interested in and appreciative of any input regarding the sentencing guidelines. So as you're using this new temporary emergency amendment, if you have any questions that come up or issues that come up, please don't hesitate to give us any of your feedback on these temporary amendments. And speaking of feedback, Krista, we have already gotten a couple of questions relating to the Fair Sentencing Act of 2010 that we really would like to take some time now to address before we move on to a discussion of our regular permanent amendments. And the first one is, are the changes to the statutory mandatory minimum penalties for the distribution of crack cocaine retroactive?
Well, and Rachel, the issue of retroactivity has been litigated in several courts. The main issue is whether the reduced statutory penalties for crack cocaine apply to defendants who committed their offense prior to the enactment of the Fair Sentencing Act, which again was on August 3rd of 2010, but are being sentenced after its enactment. There are at least 3 circuit court opinions and 1 district court opinion that have addressed this question. We would advise you to look at these opinions and others for guidance in this area. Those cases are United States versus Aggravating, which is a 6th Circuit decision decided on September 20th. Also, United States versus Bell, which is a 7th Circuit opinion that was decided on October the 20th. Also, United States versus Gomes, G-O-M-E-S, which is an 11th Circuit opinion decided on October the 1st. And then finally, U.S. versus Douglas, which is an opinion from the District of Maine that was decided on October 27th, 2010. And you know, Rachel, we've been getting another question about this particular amendment, and that is, did the Sentencing Commission make the emergency amendment in response to the Fair Sentencing Act retroactive?
And the answer is no, they did not. Any decision regarding retroactivity must be considered in the context of a permanent amendment, because the Commission does not have the authority to give a temporary emergency amendment retroactive effect. The Commission will continue to work on the issues raised by the Fair Sentencing Act during the regular amendment cycle, with a view toward promulgating a permanent amendment under 28 U.S.C. 994P. Therefore, the Federal Sentencing Act, the Fair Sentencing Act amendments that we've discussed today are not retroactive. So in other words, defendants who are in jail right now, currently serving a term of imprisonment for trafficking in crack cocaine, are not eligible to apply for a reduction in their term of imprisonment based on this temporary emergency amendment.
And Rachel, you know, we've talked about these changes as a result of the implementation of the Fair Sentencing Act, and several of the new specific offense characteristics added to the drug guideline in response to this act would increase a defendant's sentence. So the question is, do these increases apply if the defendant committed his offense prior to November 1st of 2010?
Well, you know, that's an excellent question, and a great time to remind our viewers of the rule at 1B1.11, which is that the guidelines manual in effect on the date of sentencing is the manual that is to be applied unless it results in an ex post facto violation. So the courts are going to have to make a determination because there are aggravators and mitigators as part of this new amendment. And so looking to the supplement and the guidelines manual, the court's going to have to make that determination. And if the ex post facto is violated, then the court will have to use the manual that's in effect at the time the offense was committed.
Yes, and 1B1.11, of course, is the guideline, as you mentioned, that the court will need to look to for in order to make this determination.
That's right.
Okay, we're going to move on now and discuss the permanent regular amendments that also went into effect on November 1st of 2010. However, before we describe those changes, we're going to briefly describe the Commission's authority to amend the sentencing guidelines and the process that the Commission undertakes in promulgating an amendment to the guidelines. The Commission's authority to amend the guidelines is found in Title 28 of the United States Code, Section 9940. This statute directs the Commission to periodically review and revise the guidelines in consideration of comments and data that comes to the attention of the Commission. This section also provides that the Commission consider input from authorities on and individual and institutional representatives of various aspects of the criminal justice system. Title 28, Section 994P of the Commission's enabling legislation addresses the submission of amendments to Congress. The statute provides that no later than May 1st of each year, the Commission shall submit amendments to Congress for review. The statute also states that if Congress does not affirmatively modify or disapprove the amendments within 180 days, that is, up until November 1st of that year, the amendments automatically take effect on November the 1st unless Congress passes legislation to the contrary. Now, the process of promulgating amendments to the guidelines involves, as you see from this list on your screen, the publication of proposed priorities in the Federal Register, which usually happens in the summer, review of public comment related to those proposed priorities, publication of final priorities in the Federal Register, publication of proposed amendment language around December or January, public hearings and review of public comment in response to the proposed amendment language, that happens in the spring, a vote by the commissioners on the final amendment language in April, and then finally the submission of those amendments to Congress on or before May the 1st. So this next set of amendments that we will be discussing, the Commission's regular permanent amendments, went through this process and took effect on November 1st, 2010, after the 180-day period of congressional review.
And the first amendment that we will be talking about addresses alternatives to incarceration and makes two changes to the guidelines manual. First, the sentencing table has been amended to expand both zones B and C by one offense level. Second, new language was added in 5C1.1 to provide departure guidance regarding Zone C defendants who are in need of treatment for drug or alcohol abuse or mental illness. So let's take a closer look at the expansions of Zone B and C on the sentencing table. You can see from this graphic that for each criminal history category, in each of the zones B and C, each is expanded by one offense level. So the gray area that you can see there represents the former Zone C offenders who are now going to be included in Zone B. And the zigzag line, which may be a little bit more difficult to see, but it's at the very bottom of your screen, represents the former Zone D offenders now included in Zone C of the sentencing table. Application Note 6 at 5C1.1 provides that a departure from Zone C to Zone B sentencing options is applicable in certain cases to accomplish a specific treatment purpose. This departure is applicable where a defendant is a drug or alcohol abuser or suffers from a significant mental illness and the defendant's criminality is related to the treatment problem that is to be addressed. So to determine whether this departure is applicable, the application note sets forth factors for the court to consider. The first is the likelihood that completion of treatment will address the problem, thereby reducing the risk to the public of further crimes committed by that defendant. The second factor is whether imposition of less imprisonment will increase the risk to the public of further crimes that are committed by that defendant.
Okay, we're going to move on to the next amendment as part of the Commission's regular permanent amendments. And the next amendment addresses certain specific offender characteristics in Chapter 5, Part H. Now, as you are aware, Chapter 5, Part H contains numerous specific offender characteristics that the court may consider in the determination of an appropriate sentence under the guidelines. Now, in this amendment, the Commission has modified some of these characteristics. These certain guideline policy statements have been amended to say that these particular characteristics may be relevant in determining whether a sentence outside the applicable guideline range is warranted. So as you can see on this slide, these characteristics, certain Chapter 5 Part H factors, whether individually or in combination with other such factors, may be relevant in determining whether a departure is warranted if they are present to an unusual degree and distinguish a case from the typical case covered by the guidelines. Now, the specific offender characteristics in Chapter 5 Part H of the manual that have been amended, you can see listed on this slide. They are age at 5H 1.1, mental and emotional conditions at 5H 1.3, physical condition at 5H 1.4, and military service at 5H 1.11. Now, prior to this amendment, these specific offender characteristics were designated as not ordinarily relevant. Let me also mention that, as you'll see in this next slide, the drug or alcohol dependence or abuse specific offender characteristic has been changed from being a prohibited departure provision to one that is not ordinarily a reason for a downward departure. Now, consistent with the change that was promulgated in 5C 1.1, Chapter 5 Part H was also amended to state that the court may depart on that basis to achieve a specific treatment purpose.
Now, Krista, this next amendment that I'm going to address has the potential of affecting a large number of defendants. And that is because currently in the federal system, the largest number of cases is represented by immigration cases and immigration offenses. So this amendment is the addition of an application note 8 to the guideline at 2L 1.2, which is illegally reentering or remaining in the United States. The new application note states that a downward departure may be appropriate in cases involving cultural assimilation. The application note provides guidance regarding cases in which a downward departure may be appropriate on this basis of cultural assimilation. First, if the defendant formed cultural ties with the United States from continuous residence in the United States since childhood. Second, if those cultural ties provided the motivation for the defendant's illegal reentry or continued presence in the United States. And third, such a departure is not likely to increase the risk to public from further crimes committed by the defendant. The application note also provides a list of factors for the court to consider in determining whether or not this departure would be appropriate. Those factors include the age at which the defendant began residing in the United States, the duration of time that the defendant attended school in the United States, the duration of time that the defendant resided both inside and outside of the United States, the nature and extent of the defendant's cultural and familial ties inside and outside the United States, the seriousness of the defendant's criminal history, and whether the defendant committed additional crimes after illegally re-entering into the United States.
Thank you, Rachel. The next amendment we're going to highlight for you also has the potential of impacting a number of defendants because it occurs in our criminal history guideline. And as you know, every defendant coming through federal court will have a criminal history score calculated.
Right.
So the next amendment is that the Commission eliminated the section of Guideline 4A1.1, that is 4A1.1E, that provided an additional 1 or 2 criminal history points for those defendants who commit the instant offense less than 2 years after release from imprisonment. The Commission's research on this issue indicates that recency alone is not a predictor of recidivism. Now we're getting pressed for time, and we want to make sure that we have time to address your questions that you've been sending us throughout the broadcast. And I understand we have one.
We do.
So at this point, I'm going to highlight a few other new significant amendments. The first is that at Guideline 1B1.1 in our application instructions guideline, the 3-step approach as established by Booker and its progeny is set out in the guidelines manual. So that is the first change I'd like to highlight for you very quickly. Second, in response to congressional legislation, specifically the Matthew Shepard and James Byrd Act, gender identity offenses were added to Guidelines 2H1.1, which addresses offenses involving individual rights, and Guideline 3A1.1, which is the Chapter 3 adjustment addressing hate crime motivation and vulnerable victims. Finally, the last 2 amendments I'm going to highlight before we move on to your questions is that iodine has been upgraded from a List 2 to a List 1 chemical. So that change is reflected in Guideline 2D1.11, the listed chemicals guideline. And secondly, paleontological resources were added to the Cultural Heritage Resources cross-reference at 2B1.1C1, as well as to the Cultural Heritage Resource Guideline, which is 2B1.5.
Thank you, Krista. And as you mentioned, we have gotten a question on the 2010 amendments, and it's consistent with the questions that we answered in respect to the Fair Sentencing Act, and that is the issue of retroactivity. This question is specific to the elimination of the recency points at 4A1.1E. And the question is has the Commission either made that amendment retroactive or considered possible retroactive application of that amendment?
Well, the answer to the question of whether the Commission made that amendment retroactive is no. The Commission did not add the amendment that removes the recency points from Guideline 4A1.1 to the list of retroactive amendments at Guideline 1B1.10. So therefore, a defendant who is currently serving a term of imprisonment is not eligible for a reduction in his or her term of imprisonment based upon this amendment. It was not decided that it would be retroactively applied.
Thank you, Krista. I'm sure there's plenty of probation officers that will be happy to hear that. So again, we have talked about a lot of changes to the guidelines manual this afternoon. So let's sort of recap the significant changes that we've talked about. We spent a good portion of our time talking about the changes that came as a result of the Fair Sentencing Act. Statutory changes as well as guideline changes. And let me remind you again to use your supplement in conjunction with your guidelines manual when you're applying the guidelines in these cases. We talked about the changes as they relate to alternatives to incarceration. We talked about the elimination of the recency points. We talked about the cultural assimilation departure and how that could potentially apply to a number of defendants. And we've also had the opportunity to answer some of the questions that we have had come up in the last several months as they relate to these new amendments. We understand that with all of our broadcasts as well as our live face-to-face training, that our audience has a broad range of experience. Some of you have minimal guidelines knowledge, and others of you have been working with the guidelines for a very long time. And so what we hope we've done today is we've provided you with an overview of these 2010 amendments to give you a general understanding of them. And if you have any further questions, you can certainly call us at any point and ask us those questions. If you would like for us to come to your district for additional training on this topic or any other topic, please feel free to call us directly at the number you see at the bottom of your screen. For those of you who have not already heard, our 2011 National Training Seminar is going to be in San Diego, California, May 18th to 20th. So of course we'd be happy to see as many of you there as possible. And again, if you have any additional questions regarding these amendments or any other questions regarding guideline application, you can always visit our website at www.ussc.gov, or you can call us on our helpline at 202-502-4545. So again, we've certainly enjoyed our time here with you today. We hope that you've learned about these 2010 amendments, and we thank you for joining us, and we hope that you have a great day.